My name is Rick Campbell. I've been practicing law for 27 years. I was originally licensed in Oklahoma, and I also have licenses in Illinois and Georgia. I'm with the Deming, Parker, Hoffman, Campbell and Daly Law Firm in Norcross. That's our main office. We also have an office in Savannah. We have over 50 attorneys, and I primarily practice in civil litigation, and I also manage the law firm for the other part of my time, so that's pretty much what I do. We have departments that do, we cover all the basic benefits that they have. So we have a whole division that does wills, that we prepare our clients' wills and their advance directives and their other estate planning needs. We have a whole traffic division that handles traffic throughout the metro and the rest of the state of Georgia. We have 20 attorneys or more that do the general advice and consultations for our members when they call. And that may include, in order to solve a problem, writing a letter, reviewing a document, calling a third party, whatever it takes to resolve the matter on the front end. And then obviously if it goes further, that gets transferred over to our litigation team, and we either prosecute or defend civil trials frequently on a day-to-day basis throughout the metro area. We meet with a lot of small business owners, and we see from the beginning they're very excited and knowledgeable about the area that they're going into, that whatever their business is about, whether it could be a dry cleaner, auto repair shop, or a restaurant. The problem is they haven't budgeted or thought about the legal consequences. So fortunately for those that get the Legal Shield product up front from the very beginning, they're able to access our corporate attorneys and get advice on, for example, the most important issue that comes up from the beginning is their business structure. We get to talk to them about whether or not they want to be a sole proprietor, a partnership, an S-Corp, a C-Corp, or maybe an LLC. These are real important issues when you first get started. And then when they do decide on their business structure, you're going to need an organizational agreement. If they're going to be working with a partner that they're not related to, or even especially if they are related to them, what are we going to do if things don't work out? How are we going to split up amicably? So instead of going through what we call a corporate divorce, after a year or two things don't work out, one side wants out, the other side doesn't know how much they should pay them for their stock. If these things are discussed early and a buy-sell agreement is put in place, it can be resolved amicably and people can afford it. There can be some predictability on the future of the company. And all those things they need to talk about a lawyer at the front end. And then hopefully those aren't the kind of landmines that people will run into later on down the road, which makes operating a business can be aggravating and unsuccessful. So those are the first things that we talk about. And unfortunately, when small business owners don't have access to an attorney up front and they haven't budgeted for the expense, they tend to ignore it. And the real value for our small business owners is once they buy the product, they pay their modest monthly premium, they can call an attorney as often as they want about anything. And they feel like, I've already got corporate counsel, there's no courtship period, they're already my attorneys, I'm their client, they're waiting for my call, they're there to help me, and these small things can be done efficiently, without a lot of expense, and can be done in real time so they can concentrate on their business, what they know how to do. Well, like we said, after we talk about business structure, some of the most important things that come up initially are, for example, your contracts. Almost every small business owner is going to be signing one type of contract or another. And probably the biggest ones are their commercial leases. Are they going to have office space? Are they going to buy or are they going to lease? And those leases are complex and almost invariably are drawn up and tilted in favor of the landlord, because that's who's, as the landlord's lawyer, they drafted the thing. And in most cases, with little involvement or negotiation from the lessee or the small business owner. And then you get into maybe their loans, their lines of credit with their bank, and you have contracts for your major equipment and infrastructure items, like your copiers or your phone systems, which can be very expensive. And the fine print is not always easy to understand. And unfortunately, most small business owners think that they're all the same. You just sign it and do what they say. Then, after you get that resolved, one of the scariest propositions is when you first have to hire your first employee. And hiring and firing and issues regarding having and maintaining employees involve a number of different areas of law, especially when you get into termination, wage hour guidelines, those kind of things, FMLA, whether or not Title VII applies to you, these type of things when they come up, an employer calls us and says, you know, I just got a notice from the EEOC that there's been a discrimination claim filed against me, or I've got an unemployment hearing coming up. One of my terminated employees has filed an unemployment application. These are things that become very unsettling and can distract them from their main purpose. And having access to the attorney to call up and say, no, we've got your back, you called us before this happened, everything was done properly, it gives them a comfort level that they wouldn't get otherwise without having access to an attorney. Yes, we had a client that fortunately came to our office, like I was saying earlier, and asked us to review his commercial lease before he signed it. And he was very excited about starting his company, and he was interested in signing a lease for 5 years of high-dollar retail space at a mall. And when we first looked at it, and the monthly lease amount was very high, and he told me a little bit about what he was trying to accomplish and what his business was about, and it seemed to me that it was pretty optimistic that he was going to be able to meet this type of payment obligation on a monthly basis. And the first thing we looked at was the personal guarantee requirement. The commercial landlord wanted him to personally guarantee 5 years of payment on this lease. And so when we looked at this provision, we recommended that he negotiate further, because this was it could be a huge burden on him personally. And he felt that, no, this was a lock, this was something they were going to be very firm about, they weren't going to negotiate. And we said, no, you always have to try, because you're only in business to make money. And the reason why you started the corporate structure early on that we helped him get involved in was to eliminate personal liability from your business operations. So signing a personal guarantee would be beside the point. It would defeat the purpose, in other words. So we went back to the landlord, and we were able to negotiate the 5-year personal guarantee provision down to a 1-year guarantee, which we were very happy to accomplish that, and he was satisfied with that. But then, unfortunately, we found out later that his business really only made it for 9 months, and then he had to go ahead and fold because it wasn't bringing in the kind of income he anticipated, which left 3 months on the personal guarantee. I remember it was over $17,000 he owed, and we were able to negotiate a payment plan on the 3 months remaining, which was able to keep him out of bankruptcy and save his home. So as a small business owner, we try to emphasize you're in the business of making money, not going out owing a lot of money. And that also comes up with a lot of our clients that get involved in their small business, and they forget how to handle the tax consequences properly. They're not paying their payroll withholding for their employees, or they treat employees as independent contractors instead of W-2 employees. And then when when they get a notice of levy or an audit by the IRS, they're surprised to find out that even if their business is going to dissolve, that's a personal obligation that they owe themselves, which is never going to go away. And for those of us that have called us early, and gotten advice on how to handle those things, and they've avoided those long-term pitfalls, they see the value of that so much more than the people who obviously don't have access to an attorney. And those are the kind of things we can help people do. Be in business to make money, and if it's not working out, get out clean. Don't end up in debt. What I would ask the sales associates in the field to do to help the law firm in delivering service to our small business members, the best advice I could give them is to please encourage their new small business owners to not hesitate to use the plan. Use it early, use it often, call as often as they'd like about anything that comes up. Even if to the small business owner, it doesn't seem like it's that important now, and they think they've got it under control, if they will call us and just run it by us and get our advice, they may find out that, like the other gentleman who asked us to review the lease, your call was so timely, and it helped us help you so much easier and so much more efficiently. So the problem didn't turn into litigation down the road, which would then involve a lot of money that they may or may not have. It could stop them from being able to run their business. Just to call us up, have those contracts reviewed. Don't sign them until we've reviewed them. Believe me, both sides have the right to negotiate. Have any issues with employees or questions about how to handle government agencies or compliance issues, just call us. And that's the beauty of it. There's no courtship period. We're already their attorney. They're already our client. They don't have to ask us. We're already expecting them to call. We want them to call because we really want to make sure that they maintain their membership for a long term and that they're profitable in the long run. And the only way we can do that is to go ahead and start the relationship. And the relationship doesn't start until they make that first phone call. Another area that our clients find to be most valuable is in the area of collections. I mean, when a business has a high amount of accounts receivable, that can be draining, it can be aggravating. Everyone gets a little bit upset when other people don't pay them. And when money's owed, it could hold them up from paying somebody else that they owe, and then they're getting collection calls. So it's kind of a circular argument. So when they have the Legal Shield product, they don't have to call and worry about badgering their customers that haven't paid them or vendors that owe them money. They can just turn it over to the law firm, and then we'll go ahead and send out a collection letter on their behalf under their legal benefits. And it's remarkable about how successful just a simple letter from a law firm is when collecting any amount of money, whether it's big or small. Our small business owners like to get those letters out. It keeps the money going through, and it saves them a lot of money in litigation costs and just overall aggravation.